Happy Monday and welcome to the First District Court of Appeals. We have two arguments scheduled for this morning. The first argument is case number C2-00369, City of Cincinnati versus Twang LLC. If attorneys can please identify themselves and their readiness to proceed.
William Fecker for the appellant Twang. We are ready to proceed.
Good morning, Attorney Fecker.
Morning.
Jacqueline Gonzalez-Martin for the City of Cincinnati. I'm ready to proceed.
Good morning, Attorney Gonzalez-Martin. Attorney Flecker, would you like to reserve time?
3 minutes, Your Honor.
All right, whenever you're ready.
Thank you. Your Honors, this case relates to how nuisance conditions at a building are going to be addressed. Rather than apply the statute and permit the owner of the building to use a remedy expressly enacted by the Ohio legislature, trial court improperly Twang the opportunity to establish that the demolition of the building was in the sufficient manner in which to address those conditions. That decision must be reversed. The trial court also erred in concluding that Twang's motion for summary judgment on the sole issue of whether the building was a public nuisance was, quote, facially invalid as a matter of law. That decision must be reversed. The trial court also erred in granting the motion for summary judgment filed by the city, disregarded the reality that the city failed to meet its burden of proof. It was not entitled to summary judgment based upon what was then before the court. That decision must also be reversed. Finally, this court should conclude that the historic board lacked jurisdiction over whether or not the building should be demolished, as the jurisdiction regarding that issue was first vested in the trial court before any action was taken by the historic board. The facts which underlie this dispute are not really disputed. The building owned by Twang is a public nuisance. While the city fails to acknowledge that reality in all instances, it does so only because it will do so when it wants the building determined to be a public nuisance so a receiver could be appointed. However, it is clear that the building is a public nuisance. The issues are what can be done to abate the nuisance and what consequences flow from the building being a public nuisance. The city brought this action and invoked the jurisdiction of Revised Code 376741 as the basis for its claim. That action was permitted by Revised Code 3767.41b. However, 376741e also permits the court, upon the written request of an interested party, to issue a demolition order if A, the building is a public nuisance, and B, is not feasible to repair or rehabilitate the building. This is based upon the plain language of the statute. In 2018, the Ohio Supreme Court, with Judge Myers on the panel, reaffirmed in Dundix versus Eric Petroleum that when a statute is being interpreted, the starting point is the plain language of the statute. The trial court originally recognized this when it stated, in denying the city's motion for leave to file a second amended complaint, a decision which was not appealed by the city, quote, defendant may proceed with its request for a demolition order under Revised Code 3767.41e. When the trial court issued its final decisions, however, it improperly deviated from the statement. The statute relied upon the city expressly permits Twang to request relief, including getting a demolition order. The statute cannot be any clearer. Revised Code 3767.41e permits an interested party to request a demolition order. And Revised Code 3767.41a4 defines an interested party to include any owner. The city's argument that only local governments, neighbors, tenants, and certain nonprofit organizations can seek a declaration that a building is a public nuisance is a complete misread of the statute. Revised Code 3767.41b1a does not contain any limitation on who can seek a determination that a building is a public nuisance. That section permits those entities in, quote, any civil action to enforce any local building or safety code that is commenced in a court of common pleas. If the building is alleged to be a public nuisance, then those entities may apply for an injunction or other order, including, if necessary, the appointment of a receiver.
Mr. Fecker, let me interrupt you, because if I understand your argument, the owner of a property in the first instance would be able to seek a declaration that her own property constitutes a nuisance. Is that right?
That is correct. That is based on the plain language of the statute.
And then what? She sues herself?
Well, in this case, the suit was brought by the city, and we filed a declaratory judgment action under 2721.03, requested a declaration of rights. Excuse me. Yes, under 2721.03. And under 2721.12, we are required to name as parties all persons who may have an interest in that issue. And obviously, the city has an interest in whether or not the building is a public nuisance and should be demolished.
But I guess I'm taking it a step further. If your client sought it initially as the plaintiff, what would she do? She'd have to sue herself to have herself declared, her own property declared a nuisance.
We could have filed an action and raid 819 Elm Street with the court seeking a declaration that the building is a public nuisance. That is what the statute permits us to do.
All right, thank you.
Thank you.
Mr. Fechner, let me ask you, before one of the parties can request a demolition order, doesn't the court, at least under the statutory scheme, have to first determine that it is in fact a nuisance at a hearing?
It does, Your Honor. And by
when was that hearing held?
well, our counterclaim, which requested a declaration on that issue, was dismissed by the trial court, and that's what we're seeking a reversal of. We're in a process proceeding to that hearing when the trial court properly denied us the ability to proceed with that hearing. As I stated earlier, when they denied the motion to leave, the city's motion for leave to file a second amended complaint, the court expressly stated that we could proceed with that relief. Then prior to the hearing occurring, the court dismissed our counterclaim and it denied us that opportunity. We believe that's the error, one of the errors made by the trial court.
Okay.
When the city quoted to the statute 3767.41B1 on page footnote 1 of its brief, it did not cite the entire statute. When you read that entire statute, it only states that the city and the certain entities, excluding the owner, can apply for the appointment of a receiver. Therefore, while we could not apply for the appointment of a receiver, there's nothing in the statute that prohibits us from requesting a demolition order from the court. Again, that's expressly authorized by the statute. While the city may argue that the statute rewards owners who permit buildings to become a public nuisance, the remedy is with the legislature, not to argue that the plain language of the statute should be ignored. That's basically what they're doing. They're saying we could ignore 3767.41E and the part of the statute that defines an interested party as an owner and deny us our ability to proceed with a demolition order.
Can you point us to any case in the state of Ohio that has allowed the owner of a property to seek a declaration of its own property as being a nuisance? And if so, then are there any cases that take it a step further and allow that property owner to seek demolition under the statute?
Your Honor, I will acknowledge that there is no such case. In most cases under the statute, the city has ordered the building to be demolished and the property owner is fighting against that process. But we're again relying upon the plain language of the statute that allows this to occur. When you have a statute that says an interested party can make a request to the court for a demolition order, that statute has to be applied by the court to allow the owner to make that request. While the city did argue that Twang lacks standing to and cannot request a demolition order, on page 7 of its brief, the city states, relevant here, owners can request the court allow them to demolish the property in lieu of rehabilitating it. That was the exact process being pursued by Twang when the trial court improperly prevented it from proceeding to obtain that relief. Recognizing that one element, as Judge Winkler said a few moments ago, had to be established as whether or not the building was a public nuisance, Twang filed a motion for partial summary judgment on that issue. As I stated earlier, Twang does not dispute that there has been no hearing or declaration finding the building to be a public nuisance. That was a process being engaged by Twang when the trial court erroneously terminated the process. Merely because a hearing is discussed in the statute, that does not prevent a trial court from resolving the issues through a motion for summary judgment. The summary judgment process designed the trials or hearings can only happen if there's a genuine dispute as to any material fact. In this case, there is no dispute. The building was and is a public nuisance. The city's argument that the building was a public nuisance only when it sought the appointment of a receiver to have the building repaired does not change the conclusion that the building is a public nuisance. The allegations in the city's pleadings established the building as a public nuisance. The motion for summary judgment that was filed by Twang was properly supported with evidentiary materials. The statements made by the city's attorney and confirmed by me as Twang's attorney established that the building is a public nuisance. The attorney for the city stated in court, the first part is asking the court deem the property a public nuisance under revised code 3767, and the parties have now stipulated to that. The January 7th, 2019 transcript. The facts set forth.
Attorney Flecker, is there a case out there that stands for the proposition that when the government, in this case, the city, has two options, that they should seek the one that is the least burdensome to the property owner? Do you understand what I'm saying?
I think I do, Your Honor. 3767.41 is not an off-cited case throughout the research that I was able to locate. And most cases are that the city or the government has determined the building is a public nuisance and wants it torn down, and the property owner is opposing that request. So I will acknowledge that this is a case of first impression where a property owner is using the statute as permitted by the statute to request a demolition order from the court. But I believe that that is authorized by the plain language of the statute. This court statement on the issue of whether or not the building is a public nuisance, and that could be determined on a motion for summary judgment, that the motion was facially invalid, is not based upon any application of the Ohio Rules of Civil Procedure. Nothing prevented Twang from filing the motion, and the motion was supported by evidentiary materials. While Twang believes that this court can, upon remand, require the trial court to conclude that the building is a public nuisance, that issue was not resolved by the trial court. So with the remand with instruction for the court to resolve the Twang's motion based upon the evidence would also be appropriate. Regarding the motion for summary judgment filed by the city, the trial court erred in concluding the city of Medittsburg. First, Twang is not arguing that the ordinance relied upon the city is unconstitutional. However, the city still established that the fines issued pursuant to the statute are not so excessive that the fines themselves are unconstitutional. In this case, all the fines stem from just 2 inspections and a single order issued by the court. Thereafter, additional fines were assessed merely because someone at the city pushed a button and generated a piece of paper. Those fines did not address what costs and expenses incurred by the city in continuing its efforts to obtain compliance. These additional fines were merely punitive efforts to increase the financial costs Twang for arguing its position. Additionally, the trial court never addressed the issue that there would not be any cost to obtain a vacant building maintenance license. A BBML can only be issued if the property is in a specific condition without the hazards identified in statute. To address the hazard in this case, the cost would have exceeded millions of dollars without any economic return to Twang. This is not a situation where Twang simply could have obtained a BBML. Twang was only.
Flecker, you have about a minute left.
Thank you.
May I ask you a question during that 1 minute? I want to go back to my initial question, because if I understand your position and your reading of the statute, your client could sue itself, herself, and others to have this declared a nuisance and then go the step further to have the remedy be demolition. But isn't that contrary to Ohio law that would require a controversy between parties? And if she agrees that her own property is a nuisance, her remedy is not to seek a court order, but her remedy is to demolish it herself, isn't it?
Well,
it's the controversy, I guess, under your scenario.
The controversy is that this building is within the historic district, and therefore we would have to get a certificate from the city permitting us to demolish the building. And that's what the city wants us to pursue. In fact, we did pursue that. Again, it's my position that the historic board lacked jurisdiction to issue that, because the jurisdiction with the regarding the condition of the building and how to address it was first invoked by the trial court. And once you have a trial court decision obtaining jurisdiction, it obtains jurisdiction to the exclusion of all other tribunals. And therefore, we could file a declaratory judgment action as we did. I believe that we would have to name the city as a defendant in that case. The declaratory judgment statute allows a court to determine and declare legal relations that are affected by a statute. We have 3767.41 that addresses how a nuisance building can be abated or can be addressed. And so I believe we could proceed in that fashion. That was the purpose of our counterclaim, is to end that declaration of rights. Trial court improperly denied us that opportunity when it dismissed our counterclaim. I believe my
Thank you.
time is up.
Can I ask you one final question, Mr. Fecker?
Your Honor.
You're saying the court had jurisdiction and the historic building board did not, but wasn't your client that invoked the jurisdiction of that board?
We did, Your Honor, but under Ohio law, a party cannot voluntarily confer jurisdiction upon a tribunal. And so
But-
the acts conducted by my client were improper.
My question is, you're complaining about it, yet you invoked it.
It was invoked, Your Honor, but it should not have been. The historic board should have rejected the application based upon the then pending complaint filed by the city.
Okay, thank you.
Thank you, Attorney Fecker.
Thank you.
Good morning.
Good morning. May it please the court. 819 Elm sits vacant and blighted. The people behind Twang LLC have owned it, not investing time or money for 6.5 years. The city was and is intent on doing something about it. The city's argument consists of 3 points. First, Twang's partial motion for summary judgment was properly denied and its counterclaim was properly dismissed because a property owner cannot pursue a nuisance declaration against its own property. Second, Twang cannot avoid the Historic Conservation Board because it was first sued by the city. And third, the city's monetary judgment is proper. This case hinges on the Ohio Nuisance Statute. Under Section B1A of the statute, there are only 4 types of plaintiffs who have standing to bring a nuisance case: political subdivisions like Cincinnati, neighbors, tenants, and certain nonprofits. This law was clearly crafted to protect those victimized by owners of nuisance properties, to protect their neighborhoods and communities from public safety hazards and blight. Notably, the owner of a nuisance is not entitled to bring a nuisance case against itself. It has no case or controversy with itself. And if it desires to abate its own nuisance property, not only may it, local property maintenance laws require it. There is no one on the other side of Twang's claim that it maintains a public nuisance. The city certainly did not harm Twang in any way. Twang knows that it does not get to the remedy sections of the nuisance statute until a property is deemed a public nuisance. But to be deemed a public nuisance, there must be a hearing by a judge. In Section B2B, the statute unambiguously states that a judge shall hold a hearing not less than 28 days after a property owner is served. Again, in Section C1, the statute refers to the required hearing at which a judge may determine if a property is a public nuisance. The hearing requirement makes sense because we're dealing with property rights. We don't want a building torn down or a receiver appointed without the independent judgment of a court. Twang argues that the allegations the city pleaded in its filings or emails constitute a judicial admission that the property is a statutory nuisance. If a city attorney's allegation that a building is a nuisance makes it so, then the city's cases are going to move a lot more swiftly. The statute is clear that a property's status as a nuisance is up to the judge after a hearing. Besides, judicial admissions cannot be made on a question of law. Judicial admissions must be regarding facts, not legal definitions or conclusions, as discussed in the myriad cases cited in the city's brief. Without standing, the partial summary judgment that Twang sought in this case was impossible, a declaration that its own property is a public nuisance. Next, Twang attempts to use this court to avoid its mistake of failing to exhaust its administrative appeal rights from the Historic Conservation Board. Twang argues that when Twang applied to demolish its building to the Historic Conservation Board, the board lacked jurisdiction because the city had previously sued Twang on separate grounds. Twang did not appeal the Historic Conservation Board denial, and it has now waived that right to do so. Nothing in the trial court's order, if it were overturned, would change that fact. In an effort to sidestep that issue, Twang asks this court to make a finding that only one tribunal at a time, the Common Pleas Court, was able to decide anything to do with the subject property. That is simply not the case. Authorization from the Historic Conservation Board is essentially a permit. If Twang's argument were accepted as true, then no one would be able to get a building permit if their property was in litigation. Also, administrative boards are not courts. The Historic Conservation Board is a citizen board made up of architects, developers, and historians. The Pianca case cited in the briefing is about 2 state courts. Finally, the city's partial motion for summary judgment was proper. The city issued fines and fees associated with Twang's lack of property stewardship. Twang did not pay them or appeal them. Twang has made some arguments about the fines and fees being constitutionally excessive, but it has not presented evidence that the fines and fees are excessive beyond a reasonable doubt as required. Other courts have considered and denied such arguments regarding the city's BBML ordinance. BBML fees are not fines under the excessive fines doctrine. They are fees used to offset the high cost of monitoring vacant buildings. For these reasons, the city's partial motion for summary judgment should be upheld. In conclusion, the owners of 819 Elm are trying some very novel arguments to avoid their responsibilities toward the property, but the trial court rightly decided this case and its orders should be upheld. Thank you.
Thank you. Unless there's any questions from the panel. Thank you for your argument this morning. Counsel,
I got it. Thank you. I apologize.
right. No worries.
In rebuttal, Your Honors. The city continues to misread the statute. There is nothing in 3767.41B1A that says only the city or those other entities can apply to a court to request a public nuisance determination. The word only does not exist in that statute. There is nothing in B1A that relates to or impacts any other section of the statute, specifically 3767.41E. And there's nothing in 3767.41E that is limited by 3767.41B1A. It simply does not exist. The statute clearly states in 3767.41E, upon the written request of any of the interested parties who have a building that constitute a public nuisance demolished, because the repair and rehabilitation are found not to be feasible, the judge may order the demolition. It clearly requires a legal action to obtain the relief permitted by 3767.41E, and 3767.41 A4 defines interested party as any owner of record in any property that becomes subject to the jurisdiction of a court pursuant to this section. So while there are limited number of entities that can proceed to have a receiver appointed, which is the relief that flows from an action being taken under B1A, and the issues, the remedies that are discussed in subsection C, those do not limit the application of 3767.41E. The statute could not be any clearer. And that is the relief that we were entitled to, and what the trial court erred in denying us that the opportunity. I agree with the city. There must be a hearing. And we were in the process of proceeding with that hearing when the trial court improperly denied our application and denied our motion for summary judgment.
Now, Attorney Flecker, the city seems to depart on your analysis with regard to the jurisdiction of the administrative board.
Correct, Your Honor. For the first time, they're now arguing that the historic board is not a court. If the historic board is not a court and its decisions are not entitled to res judicata effect, under Ohio law, only tribunals' decisions are entitled to res judicata effect. So therefore, there is case law that says decisions by a historic board are entitled to res judicata effect. That makes them a tribunal. A tribunal must have jurisdiction before it can act. And in this case, the condition of the building and how the building was going, how those conditions were going to be addressed, were first invoked by the city in its filing with the trial court in its original complaint and its First Amendment complaint, when it specifically sought relief under this statute. We
Because
filed
if
a,
the city's argument today was correct, wouldn't you be able to then just go ahead and go back to the historic board and seek for the historic board to allow for the case to be for the for the building to be demolished?
if that position is correct, that remedy would be available to us. But we prefer the remedy set forth in the statute that allows us to apply for a demolition order if we can establish that the rehabilitation and repair of the property is not feasible. We're already, months into that process. We were about to have the hearing was scheduled for just a short time after the decisions were issued.
Because presumably, if they were correct, I assume that the building is in even worse condition than it was when it was first before the historic board.
It is, Your Honor. Yeah, I mean, she is correct. We have not done anything because, again, it's not simply a matter of getting a BBML license, of making that application. You have to satisfy under the ordinance that the building does not contain certain conditions. And our evidence, if we were able to show it, would establish that the cost of making those repairs and improvements would be millions of dollars. It would not generate any income, any return on that investment back to Twang, which is one of the conditions and issues that come up in a hearing under 3767.41E. I'll just briefly address, I'm not too sure how much time I have left, the issue of the fines. There is no additional cost. There's both VBML fines and also fines because Twang did not remedy the condition. There were multiple exhibits, but those exhibits all related to a single inspection and 2 reports. And therefore, the fines that were issued for just merely pushing a button and issuing a piece of paper would be excessive fines as applied under the Ohio law as interpreted by a number of different courts. Unless I have any time left, I'm finished. Or are there any questions? I'm finished with my presentation.
My question is, you say they just pushed a button. Based on the briefs, it sounds like the city had an inspector look at your client's building at least 6 times since the initial request to bring it into compliance. Am I incorrect in that? I thought there were 6 inspections.
Respectfully, Your Honor, you are incorrect. If you take a look at the exhibits attached to the city's motion for partial summary judgments, exhibits F, G, H, I, and J, they all relate to a single inspection occurred on August 10th, 2017.
Okay.
The city did not come out on additional dates and issue new notices. And in fact, if you took a more detailed look at those, I apologize, Your Honor, the date of inspection is August 8th, 2016. The city's notices issued as referenced by exhibits F, G, H, I, and J all relate to a same notice date of August 10th, 2017. And they are basically the same. The date of the inspection I'm referring to is City Exhibit B.
Okay.
And the original notice is City Exhibit E. And the additional ones are City Exhibits F, G, H, I, and J. I apologize, I got that date incorrect, Your Honor.
Okay, thank you.
That leads me to one follow-up question. If we were to accept your reading of the statute, isn't it possible then that somebody could come and buy a piece of property in the historic district, which is subject to certain conditions before it can be demolished, hold on to that property without doing anything for a sufficient time for it to become a public nuisance, then sue itself to have it declared a nuisance and demolish it?
Again, Your Honor, I believe that is authorized by the statute. And as on the panel you were held, you start with the plain language of the statute, number one. Number two, at the time the Twang acquired this building, these conditions existed. The floor had already fallen through. The building had been vacant for years. Windows were broken out. All those conditions already had existed. So to take your example, if we take a building not in a subprime condition, in a nuisance condition, and the building owner doesn't do anything, the city has steps to work earlier to address those conditions and require those repairs or rehabilitations before the cost exceeds a reasonable economic return. So the conditions that you set forth would not apply, and I believe there are an opportunity for the city to prevent those from occurring why they have the VBML process and why they have city inspectors inspecting buildings. And if they had acted sooner, then perhaps we would not be here. But again, when Twang acquired the building, those conditions existed, and it was determined that it was not feasible for it to be repaired.
And I'm just curious, Attorney Flecker, had the city not filed anything, what remedies would your client have had before the historic board?
Before the historic board, we would have filed an application to address the issues at that point in time, or we could have filed a declaratory judgment, our own declaratory judgment action, NRA 819 Elm Street, naming the city as a defendant because we're seeking a declaration of rights. And again, under 27-2112, we have to name all persons who have an interest in the outcome of that declaratory judgment action to request a demolition order. And the city could appear in that action or not appear in that action.
Thank you. Thank you.
Any further questions? I appreciate my time, Your Honors.
Thank you both for your arguments this morning. We will take the case under submission and issue a timely decision, and we wish you a wonderful week.
Thank you.
Thank you.
Good morning, Your Honors.
Good morning.
Morning.
Good morning. We're now here on the second and final case. Case number C200270, 271, 272, State of Ohio versus Sonia Staley. If attorneys can please identify themselves and their readiness to proceed.
Good morning, Krista Gieske on behalf of defendant appellant Sonia Staley, ready to proceed.
Good morning.
Good morning, Your Honors. John Vogt on behalf of the City of Cincinnati, appellee, ready to proceed.
Good morning. Attorney Gieske, would you like to reserve time?
Yes, Your Honor, I'd like to reserve 3 minutes, please.
Whenever you're ready.
Thank you. May it please the court, Mr. Vogt. Most police officers are upstanding civil servants, but we are at a pivotal time in history where credibility of the few bad apples has taken center stage. And transparency in state action is more important now than ever. The instant case hinged upon the credibility of the state's sole witness, Officer Carlos Sherman. Defense counsel diligently filed the requisite pretrial motions and a public records request to obtain the information in this officer's personnel file. Only Officer Sherman's commendations were turned over. So what defense counsel did not find out until after Ms. Staley was convicted is that there were at least 20 private citizen complaints against Officer Sherman between 2009 and 2013. And we don't know how many more were filed since then. That's because the state suppressed all negative information pertaining to Officer Sherman's record. So Ms. Staley's second, third, and fourth assignments of error offer this court different routes by which to condemn this Brady violation.
Can I ask a couple questions before you get into the legal arguments?
Sure.
So there was a discovery demand. The state, you're saying, then provided a portion of his file?
Correct.
To defense, and the file only contained commendations?
That's correct, Your Honor.
Okay. And then the Citizen Complaint Authority documents were found in a public, well, they were found on a database, right? Not through a public records request?
It's not totally clear how much of the database was public, but yes, counsel, it was brought to her attention sometime after conviction in this that this database exhibited these complaints.
Okay, and then the complaints that she discussed with the judge, she did not file into the record for us to look at, right?
No, because I believe the complaints themselves are not publicly available. I think the database is just that. It's a database of the complaints that exist, But from what I understood from the record of what counsel said, the complaints themselves and the specifics are not publicly available.
They're not even able to get through a public records request?
That's my understanding from the record, that the actual complaints themselves are not available.
Okay. Thanks.
You're welcome. So, under the second assignment of error, that there are 3 elements to Brady claim. And the first is that the evidence is favorable to the accused. And this element is easily met because information that is impeaching is considered favorable to the accused. And this is clearly impeachment evidence toward Officer Sherman. The second element is that the evidence was suppressed by the state, either willfully or inadvertently. Again, this element is easily met. The commendations were turned over only when the negative portions of the record did exist. And then the third element is that the accused suffered prejudice as a result. So prejudice is defined as it's when the state suppresses evidence that is material for Brady purposes. And materiality is met where there's a reasonable probability that the result of the proceeding would have been different. And it's important that that we keep in mind that this is not a sufficiency of the evidence test. One way that the materiality element is looked at is, does the withheld evidence undermine confidence in the verdict? And here, Officer Sherman was the state's one and only witness. The 3CDC employee was subpoenaed and did not show. So the state's case did hinge entirely upon this one individual. So if it was brought to light that there were numerous citizen complaints against him that accused him of targeting individuals, particularly if, and again, we don't know all of the details, but if these complaints are all or mostly filed by Black women, as Ms. Staley is, it would lend more support and undermine his credibility, so that it would undermine confidence in the outcome of the verdict.
In what regard, though? I mean, what portion of his testimony are you saying was not credible?
So there were a couple of points. Even at trial itself, the officer refused to acknowledge anything that would put Miss Staley in kind of favorable light. So, for example, when she tried to say, when defense counsel asked him, she had a condition, a medical condition, and she was laying on the bench, right? And she said that. And he said, no, she didn't tell me that. And counsel rewound the body cam video a few times where she could be heard saying it. And it is a bit muffled, but he flat out refuses to acknowledge that she had anything wrong with her that would necessitate laying down.
But you have a video. I mean, we watched the video, and we can see what was said. And in a case like this, where you actually do have a video, how is the fact that he denies what seems to be in the video? I mean, the judge had both of those things right in front of him, right?
He did, but toward the end of the proceeding, the judge congratulated the officer on what a great job he did. So obviously he seemed to be viewed in a favorable light to the court. And the court, we tend to presume that police officers, as we should, are telling the truth, are being honest in their assessment of the situation. And his credibility on that point, obviously the judge bought into the impression that he was giving. But
what does that matter anyway? Like, let's say she does say she has a medical condition. How does that help your case as far as the fact that he told her she's not allowed to lie down and she has to leave, and she didn't leave?
The first charge, whether or not that he properly revoked her privilege, is relevant to sufficiency on the criminal trespass. So, the existence of this rule, whether it's a real rule, whether he had the power to enforce this supposed rule, are all relevant to the criminal trespass, and then ipso facto to the resisting arrest, because you need the rightful arrest underlying it. So it directly speaks to that offense. And then the overarching issue is, if we seek to encourage full discovery, disclosure, uphold Brady rights, the state, we cannot have trust in the system if the state's going to turn over partial information, especially when, as Justice Ginsburg said in the case that we cited, that the defense does not have the duty to root out any undisclosed favorable evidence. And when the state hands over only positive evidence, it implies that that is all that exists. And that is not something that this court or any court should encourage if we seek to have faith in our discovery process and in our criminal legal system.
Do we know that Citizen Complaint Authority documents, do we know that they would be in his personnel file?
I don't know that the exact database, I don't know that the exact, for one, I'm not positive that that is a database of which counsel spoke. I would imagine a personnel file would have the corollary to commendations, which is negative reviews.
But I guess my question is, how on this record do we even know that the state withheld any evidence that was favorable to your client?
Counsel did everything that, I mean, what more should defense counsel have done though? As soon as she found out, the day she found out, or the morning after she filed this document requesting new trial to make a record, they had a hearing on it. You know, what more are our defense attorneys to do in order to fulfill their duty, in order to preserve this with what counsel had at hand at the moment? She did everything that she was supposed to do. And
is it for us to say that the state committed a Brady violation, that the state didn't turn over favorable evidence? I mean, don't we need more than just speculation that this stuff might have been in the file and we don't even know what it said? I mean, don't we need more than that?
But even though defense counsel wasn't 100% sure what was in the complaints, the headings themselves that were publicly available, you know, it was discourtesy, failure of duty. I forget the exact headings, but those are enough to suggest that there is negative information out there pertaining to this officer. And as any of our higher ups review our job performance, there's going to be good. It just stands to reason there's going to be the good and the bad in our personnel files for all of us. So unless the city of Cincinnati does not police their police and, you know, keep a record of any negative information, that information is going to be in there. So counsel did what she could to preserve the record with what she had in the moment. And what she did present is it's our position that that is sufficient to at least raise a question about what this officer does, how he treats private citizens. These 20 complaints in this short time span, and we don't even know, it was not available how many more since then.
Attorney Gieseke, can we turn to your sufficiency argument?
Yes,
This was a public park, was it not?
it was, Your Honor.
There was, in the record, is there any evidence as to whether there was posting of this new rule?
Your Honor, there is no evidence of this rule that's firm in any sense of the word. When the officer was asked if he read the rules for Ziegler Park, he said he did, and then said he didn't remember this rule. He didn't recall seeing any rules about this prohibiting lying down in a park. So the city did not submit any text. You know, the rules of a public park have to be passed by a resolution of the appropriate governing board, and we have no evidence of record that this rule existed at all.
Now, there was some evidence with regard to the agency of 3CDC, is that correct?
Yes.
And what exactly was the evidence of that agency? Was there any evidence that that agency allowed 3CDC to change the rules?
No, and the only evidence in the record was actually incorrect, as we pointed out in our brief, about the parameters of this park and who owns. You know, 3CDC is just a management company. They don't have the power to control citizen rights in the park. Again, the city of Cincinnati owns the property, and so the city of Cincinnati has the power to make and enforce the rules. And this is actually a point where Officer Sherman's credibility is important because, you know, this didn't come in any hard evidence about the rule. Not only that, but the rule we could see from the video is being selectively enforced when you see that the woman doing yoga who testified in favor of Miss Staley is not being told to get up. When Miss Staley is walking out of the park and Officer Sherman is following her, If you look, you can see in the background, there's another Caucasian person laying in the
But
grass.
even before we get to whether the rule was applied unilaterally and equally and fairly,
Sure.
I'm still trying to understand what the evidence was as to who was able to promulgate, change those rules, that then the officer, was believed that he was taking on at that point.
You're correct, Your Honor. There actually is no evidence put into the record about the existence of the rule at all, or how it's enforced, or who can enforce it, or who can change it. The record is totally silent on that point, which would, undermine the state's case on the sufficiency argument for criminal trespass, because, the first element is lack of privilege, and there's no proof that she lacked privilege.
Wait, do you need to have a rule though? A posted rule? I guess I thought the lack of privilege was the officer testified that he was requested by 3CDC to assist him, and they said that people can't lie down, and so he was enforcing whatever it was, but he's the one that revoked her privilege, right? Have a rules on a board?
But again, this is where his credibility is so important, because Amanda Goodwin, who was the girl doing yoga, testified that she was present when the 3CDC employee came up to talk to them, and that it was a pleasant conversation, and that it was only about the event going on later that day, and that there was no evidence, no acrimony between the parties. And she's a disinterested witness, Amanda Goodwin.
But that's a manifest weight argument, right? Not a sufficiency.
It is. But, it is a public park, and a police officer, even if he's a public figure, cannot arbitrarily come up and revoke someone's privilege to be on public property. Again,
that goes to my point, whether 3CDC can arbitrarily revoke somebody's privilege.
Your Honor,
if the officer is behaving under the authority of 3CDC, doesn't 3CDC have to have authority to change those rules within their agency relationship?
Yes.
Is there evidence as to such?
There is not. So you're correct, Your Honor. 3CDC is just the management company, and there was no evidence offered by the state that they have a right to participate in the creation or alteration of the park rules whatsoever. So this officer, his authority is and has to be limited. Otherwise, private citizens can easily be targeted. So there was no evidence put in by the city that 3CDC had any other duties or powers other than the general management of this park, and that does not involve changing the rules.
Ms. Giese, let me ask you a question. You seem to be implying that this officer in the 3CDC employee targeted this woman. As you know, we've watched the video. Officer Sherman is a Black officer, and the employee at least appears to be Black as well. So you're saying that they're doing some unjustified enforcement against people of their own race?
2 points to that, Your Honor. One, there is Black on Black racism.
Because there's white on white racism too.
There is, yes. So just because of the same race doesn't mean we can discount the racism argument.
But you're making us speculate. I mean, what evidence do you have based on that video? Your client is her worst own enemy. All right. And the officer, what I could see on the video, all he was polite to her. She's calling him every name in the book, causing a ruckus. There are kids everywhere. How do we assess his credibility when everything is on video?
Well, one other answer quickly to your is we are not saying the 3CDC employee targeted her in any way. Again, the evidence does not support that the 3CDC employee even told her to get out. Amanda Goodwin's testimony dispels that. As far as he's nothing but he follows her, 200 feet across the park, and then at the end culminates in grabbing her hair. I wouldn't say that that's not what I would say is upstanding officer conduct.
Well, but wasn't that when the female officer was trying to cuff her?
Yeah, and Miss Daly was submitting to the female officer. He was trying to get his cuffs in because he, just had to be the one to do it. He wanted to be, she was actually relenting and submitting to the female and wanted the female. She was justifiably upset with this officer's targeting of her and was trying to submit to the female, and he was trying to get in there. And there was no need for that.
Okay, thank
So-
you, Ms. Geeske. Thank you for your argument.
Thank you. I'll reserve the remainder of my time.
Good morning, Your Honors. Opposing counsel, and may it please the court, this court should overrule all the assignments of error and affirm the judgment of the trial court. And with your permission, I'd like to first discuss the second, third, and fourth assignments of errors. I want to be absolutely clear here, and that is that the prosecutors who were involved in the trial and discovery process of this case absolutely did not commit a Brady violation or prosecutorial misconduct. And I think before we even talk about the law in this case, it's important to get some of the facts straight. So the trial prosecutors did not selectively edit or even turn over the personnel file in this case. That was obtained through a public records request filed presumably with the Cincinnati Police Department, of which the trial prosecutors were completely unaware. Counsel's own motion and appellant's brief indicates that those complaints from 2009 to 2013 were public information in the truest sense of the word, and that they were publicly available via a database online, not even through a records request, the entire time before and during trial. So contrary to defense counsel at trial in Staley's brief, these complaints could have been used subject to the rules of evidence at trial if they wanted to. So the important thing, and you asked about this, Judge Krause, is that these complaints are not in the record. They weren't attached, or even the database of the complaints or whatever it is. There's nothing that was attached as an affidavit or an exhibit to Staley's motion for a new trial. So moving to the law, because they're not in the record, Staley has failed to demonstrate that they're exculpatory in nature. I would point out from Staley's motion for a new trial, it does appear, they say that there were about 20 complaints against Officer Sherman in that time frame, only 2 of which were sustained. So just as a matter of course, you have 18 unfounded complaints. I'm not sure how that's even usable at trial for impeachment purposes. But even for the sake of argument, if they were exculpatory, Your Honors, Staley has failed to show that the outcome would have been different, that they were materially exculpatory. And as this court pointed out, you all asked questions about this, that the offense is completely on video. You guys have seen the video, which speaks for itself. Sherman was thoroughly cross-examined as to the video and his supposed discrepancies between his recollection of what occurred and what the video showed. The trial court was in a position to weigh any differences. And the trial court itself questioned the relevancy of 6 to 10-year-old complaints, even assuming, for the 2 that were sustained, what relevancy they would have had to Ms. Staley's case in 2019. So just in conclusion, with regard to the Brady violations, Your Honor, Staley has failed to demonstrate the exculpatory nature. She's failed to demonstrate that the material was inadvertently or intentionally suppressed on the state's part, and she didn't suffer any prejudice as a result, even if those 2 things did occur. So for similar reasons, again, for the prosecutorial misconduct, Staley has failed to demonstrate the materiality of any evidence that was supposedly withheld by a prosecutor, which again, it wasn't. Prosecutor didn't turn over the personnel file. Staley obtained that herself. As to the 4th assignment, Your Honors, trial court did not abuse its discretion in denying motion for a new trial. Criminal rules 33A2 and A6 both require affidavits to be submitted, and none were filed with this motion. The complaints, the CCA complaints aren't in the record, and I don't think the personnel file is actually. So the timing of the motion, I think, is also important as well. It was filed 161 days after trial, well outside the 14-day and 120-day requirements for each of those 2 motions sections, respectively. Irrespective of any delays from COVID for setting a new date at trial, I mean, Staley's counsel could have filed those motions at any time. So that was on her. What could she have done differently? If she wanted to use publicly available information at trial, she could have done that. So this court should overrule the 2nd, 3rd, and 4th assignments of error. Moving on to the sufficiency and manifest weight assignments for trespass, DC, and resisting. I think I can clear up some of the trespass questions specifically that you asked, Judge Zayas. And I don't know why it's in the record, and certainly Officer Sherman doesn't have to be explicitly capable of stating every park rule, but it's specifically, and presumably the trial court was aware of Cincinnati Park Board Rule 37. And it states that no person may lie upon any bench or ledge on park property. It's Park Board Rule.
That wasn't in the record, right?
No, it
Okay.
wasn't in the record. It doesn't say it on the
So
complaint,
it
but
wasn't mentioned anywhere
no,
that
it wasn't.
there's a park rule.
No, I agree,
Okay.
with that, Your Honor, but the trial court, its job at trials to apply the law, and it presumably was aware of the park board rule. And if it made a determination with regard to trespass privilege at the trial court doesn't need to state, I rely on Park Board Rule 37 in finding this person guilty of trespass. But the court certainly is capable of, applying the law that exists. And this law was in place at the time. Park Board Rule regulations have been in place
Well,
for.
again, it's not in the record. And, just like we've been asked to take judicial notice of the website, which by the way shows people lying down, that's also not in the record.
I agree with that, Your Honor. I think there's a difference between taking judicial notice of a website or evidence. But we're talking about, this is a law that's incorporated via the Cincinnati Municipal Code. Any violation of a park board ordinance is a minor misdemeanor. So
Do we need that though? I mean, do you need an actual rule to win your case here?
no, I don't think so, Your Honor. But I just wanted to clarify that rule, that this wasn't some art, that it does exist. And I think there's a distinction. The rule also states that a person can't lie down on the ground if they're blocking an entrance or an exit or a walkway. So there's a difference explicitly in the rule. A person can do yoga and lay down on the park via, rather than lying on a bench. I mean, whether you agree with the rule or not, the rule, I think it exists, and I think it was applied properly in this case. I'd also just point out, Judge Zayas, the website for Ziegler Park that you're asked to take judicial notice of also includes the basketball courts. It says Ziegler Park features basketball courts, so that would seem to undercut Ms. Daly's assertion that she didn't know that she was going back into the park.
It also undercuts your argument because it shows people lying about and enjoying the park on the website.
I
which is
respectfully disagree with that.
Contrary to this rule that the officer was asked to enforce.
Well,
So
Mimi,
I guess ultimately, is there any evidence in the record with regard to the nature and the extent of the agency relationship between 3CDC and the city of Cincinnati Parks?
No, Your Honor. And again, I'm not as concerned about that from my perspective. I think the rule to continue on, no person may lie upon the ground in a manner that obstructs entrances, exits, passageways, or the safe movement of pedestrians.
But that's
So
not what she was charged with. And
no, I know that. My point is,
and I don't know if you noticed this or researched this, but when I looked at the complaint with criminal trespass, it was charged as an A1, which is knowingly enter or remain on the land. But it seems as if it proceeded as an A4, which deals with notification of an agent and failure to leave thereafter.
I think,
what do we do with that?
Your Honor, I viewed the evidence, again, in terms of a sufficiency or manifest weight analysis, I viewed the evidence that she did fail, that she remained on the property after being told not to. I mean, the court has certainly seen the video where she was asked to leave numerous times and kept stopping to engage in Officer Sherman.
But isn't that
That's
an
how I view
A4
it.
violation?
I'm sorry, Your Honor.
Isn't that an A4 violation?
Your Honor, I hadn't considered that. I don't have that in front of me. So I just think that on the light most favorable to the state, she failed to, she remained on the promise that she, without privilege to do so, remained on the premises of the Cincinnati Park where she was told she had to leave for violating the park board rule.
well, Mr. Vogt, it sounds like your argument is that, individuals are presumed to know the law. You're saying this park board rule is the law. Wouldn't that just, couldn't she argue then that I was unaware that I'm not permitted to commit disorderly conduct? I mean, that could be the argument if she's, people are presumed to know the law. That's my understanding, at least. And is that what you're arguing here? That a park user is presumed to know the law as it applies to park rules?
Well, I think, I think ignorance of the law is not an excuse. I think that's obviously a maxim of criminal law. So that's my answer to your question, but especially in terms of the mens rea after, to your point, Judge Krause, after Officer Sherman informed her that she had to leave, then she, at that point, knowingly or recklessly remained on the property.
I guess that's where I'm getting confused because, the record was clear. First of all, that park rule, whether it existed, was never mentioned. The officer testified that the rules were not posted. He also testified that he was asked to assist a 3CDC employee and that there was some sort of rule. And I guess my question is, do we need to find that there was a rule, or do we need to find that the officer believed there was such a rule, and then she told her she was violating it, and because she wouldn't comply, he revoked her privilege? I mean, I guess I'm wondering if this rule is necessary to your argument.
Yeah, I think it's the latter point. I think that's a good distinction, Your Honor. I just wanted to, it was my goal today to sort of clear up any sort of confusion with regard to that rule. But I agree with you. You don't need to find that Miss Staley violated Park Pool Rule 37. I mean, she wasn't, charged with that minor misdemeanor. She presumably could have, because the record plainly shows her laying on the bench. So no, I don't think you need to get there. I think in terms of a sufficiency argument, no, you do not need to get there. Moving on to disorderly conduct, the brief talks a little bit about the fighting words authored by my colleague. I would just, again, sort of rest on that a little bit and ask this court to join the other districts cited in our briefs with regard to the use of racial slurs not being protected speech. But I wanted to point to a few parts of the record in State's Exhibit 1, the video I'd ask this court to really look at with regard to fighting words towards officers.
Before you get there, I also look at the complaint for the disorderly conduct. And the facts that were presented there was used hardcore profanity in the presence of small children. But it also charges it as an M4, where the facts do not rise to an M4, because in order for there to be an M4, there has to be persistence. But that's not how this was charged. So what do we do with the fact that it was charged a certain way, and it was charged with regard to the children? Looking at the entry, the conviction was as to her behavior towards the officer, and also that the charging document was flawed to begin with, because it was charged as an M4, but didn't have the supportive language for an M4 and had supportive language for a minor misdemeanor.
My response to that question, Your Honor, I mean, in terms of the notice pleading requirements of criminal complaints, that she was put on notice that she violated disorderly conduct from a misdemeanor to 4th degree level, I agree that M4 disorderly conduct does require persistence. And I think in a light most favorable to the state, that was demonstrated at trial via Officer Sherman's testimony, and especially State's Exhibit 1. Talking a little bit about the alarm to the children, I think State's Exhibit 1 plainly shows that. You see numerous children that are around Miss Staley as she's loudly swearing, using racial slurs, and they're standing around, frankly, in a light most favorable to the state, looking alarmed. And plainly, within the first 2 minutes of interacting with Miss Staley, Officer Sherman puts her on notice that says, if you keep doing this in front of the kids, I'll arrest you for disorderly conduct. So I think that was satisfied. I think the complaint probably—
And what that goes to is whether an MM was established by the record. I think that would be, I don't know, you would get much argument on that point.
Well, I think she just persisted in your. I think State's Exhibit 1 and the testimony is just our best argument for, I mean, that persistence was plainly demonstrated at trial.
But
and
what do
the
we do with the fact that the charging document doesn't, um, doesn't, doesn't state that she's charged for persisting? And the state never moved to amend.
Your Honor, I do not believe that is fatal to the state's case. The complaint plainly indicates that she's charged at the M4 level, and the state, in a light most favorable to us, demonstrated that she persisted and met the definitional elements at trial. But just getting back briefly to the fighting words portion, I agree that we do focus on that in our brief, and I want to be clear that it's not just the names that she called Officer Sherman. If you're viewing this in a light most favorable to the state, at approximately 3 minutes and 5 seconds into the body cam footage, she tells Officer Sherman, "You're lucky I had my son with me. If I didn't, you would have needed backup." About a minute later, she says something, and it's kind of mumbled, but she says, "If I see you without that badge on." So, I mean, she plainly threatens him, or implies a threat to Officer Sherman. So I think that plays in our favor as well. Moving on to the resisting arrest, even if this court finds that we didn't meet our burden beyond a reasonable doubt with regard to trespass and disorderly conduct, Sherman only needed probable cause to arrest, and he's also entitled to a reasonable mistake in that regard. And again, not from our perspective that there was any mistake in this case as to the trespass and disorderly conduct. Just moving to the record, she was told she was under arrest, and she refused to put her hand behind her back for over 2 minutes, I think from 5 minutes and 40 seconds in the body cam to about 8 minutes and 5 seconds. She pulled away multiple times. I'd respectfully disagree that he did place her hand on her head, and I don't think that's excessive force. The record shows it was there for about a second as she was physically resisting. So he didn't yank her hair back or throw her to the ground. There's no testimony with regard to any injury that Miss Staley supposedly suffered as a result of Officer Sherman placing her under arrest. So in a light,
You have about a minute left.
well, Your Honor, that's actually pretty much all I had, unless there are any other questions. We ask this court affirm the judgment of the trial court, and thank you for your time.
Thank you for your argument this morning. Attorney Gieseke.
Thank you, Your Honor. Number one, the absence of an affidavit accompanying the motion for new trial was an argument that was waived. The trial court entertained the motion for new trial without affidavit, so the state cannot now rest upon that argument. Regarding this Park Rule 27, as you noted, recognize that, 37, that is absolutely not in the record. And it's appellate practice 101, you can't add to the record. Can I talk about the other cases in my office where Officer Sherman did this to other Black women? No. So in the same way, counsel cannot add to the record with this Rule 37. As far as Judge Zayas, your argument about the elements being altered, A4 versus A1 on the criminal trespass, I think you hit the nail on the head with that argument that you cannot change the identity of the offense partway through without going through the formal amendment. So as far as the criminal trespass and the disorderly conduct, what the state is suggesting would alter the elements, and defense counsel did not have an opportunity to defend against those new offenses. So the rules allow you to amend the charging instrument up to a certain point, and that does not include on direct appeal. So as far as this persistence, defense counsel did not have the opportunity to defend. This court cannot look back and do a de novo assessment of the facts to see whether they fulfill this persistence element. That was not before the trial court, and defense counsel had no chance to defend that element. And, a lawful...
But she was charged with an M4, right?
She was, but there's the state did not, just like with the criminal, it was with the DC. The various levels can be, alarm. I forget what the other ones are, but the complaint limited that allegation to alarm. So that is what we're on notice of. When the complaint itself narrows, then that is what is argued at trial. Then that is the theory upon which the state has rested its case.
Ms. Gieseke, isn't the court allowed to make a finding as it conforms to the evidence? I mean, if she was charged with an M4 and the court determined that it was persistent based on the video, is not the court permitted to amended to conform with the evidence.
But again, counsel did not have the opportunity to elicit testimony going to these new elements. So that would not be appropriate. We would submit under the circumstances. You know, you're allowed to do de novo determinations.
Yeah, doesn't the video sort of show maybe a persistence?
Again, that was not before defense counsel to even be on notice to have to defend that element.
Well, it seems that he or she would have perhaps known that after watching the video.
We have to stick to what the charging instrument in order to conform to constitutional rights of the defense, the defendant.
How did this change the identity of the offense?
If you proceed, so there was a case that I drafted as a clerk for the 12th district, and when they charged the guy with the wrong, it was the upskirt provision of voyeurism, and they charged him with the wrong section. And as much as we did not want to reverse that conviction, we had to, because from the beginning it was the wrong section, and you couldn't go forward with that. And I can't remember the name off the top of my head. But when the wrong subsection is pursued, you can't alter it after the fact. And that would be our position on that. As far as a lawful arrest is an element of resisting arrest. So yes, it's a probable cause standard, but probable cause is higher than reasonable suspicion or a hunch. You know, you have to have the actual elements of the offense met. And here, you know, as far as I can tell Judge Krause that it's not important to you to have the privilege or the rule that the officer, you know, can possibly revoke the privilege. Even if he can, you've got the mens rea that has to be met. That's knowing. You know, counsel made a brief reference to recklessness. That is not the standard. It is knowing. So did she know that crossing the street and going into the courts put her back on Ziegler Park, you know, property? I don't think that would necessarily be common knowledge.
Well, he already told her before she even crossed the street she was under arrest for disorderly conduct, right?
I believe he said it when she entered the street, if I remember correctly. I haven't watched the video in a little while, but
I watched it recently, and I recall him telling her before she even went to the basketball court that she was under arrest. So I don't know if that really even matters to our analysis, does it?
I think he had predetermined that he was going to arrest her anyway, yes.
Right. So the fact that she went to the basketball courts, which is on the property, I mean, that's all after he already told her she was going to be arrested. She had to stay on the property. He already told her she was going to arrest her.
She was picking up the minor children, you know, she was going to pick up these minor children. So she couldn't leave without these, you know, I think early, you know, they were definitely minors. I remember that. So she couldn't just leave. And, you know, just because she wasn't leaving fast enough for his taste doesn't make her actions criminal. And as far as the last thing I'll say is, as far as the DC, you know, for fighting words, police officers are expected, they're held to a different standard, as they should be. We need to be able to have our private citizens speak against police to live in a free state. And, you know, it has to rise to a clear and present danger of a serious substantive evil. I don't think that her words, even calling him, even, you know, racial slurs, clear and present danger of a serious substantive evil. You know,
Thank you for your argument this morning.
Thank you. We would ask that you reverse and discharge or remand for retrial.
Thank you both for your arguments this morning. We will take the matter under submission, issue a timely decision, and have a wonderful afternoon.
Thank you, Your Honor.